Bonjour tout le monde.
Hello, everyone. Let us begin by officially beginning the meeting. Welcome to meeting number 22 of the meeting of the Standing Committee on Public Safety and National Security. Pursuant to the reference from the House of Commons, we will be resuming the study of Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. I would like to welcome our witnesses that we are starting to get to know them well. They will be asking our questions if we have any. So from the Department of Public Safety and Emergency Preparedness, we have Mr. Colin McSween, who is Director General, National Cybersecurity Directorate, Kelly Ann Gibson, who is a Director of the National Cybersecurity Directorate, and from the Department of Industry, Mr. André Arbour, Director General, Telecommunications and Internet Policy Branch, and Mr. Wen Quan, Director General, Spectrum and Telecommunications Sector. There are other officials who are in the room behind the witnesses at the round table and who can come to the table if they are needed to answer any of your questions. Let us now continue our clause-by-clause study of the bill. And we are now at BQ1, and a notice was sent. Is BQ1, has it been tabled? Madame de Bellefeuille, you have the floor. Very good. So I have tabled the amendment, and it basically goes back to the recommendation of the Commissioner on Privacy to standardize the bill with the criteria of reasonableness, proportionality, necessity as well, to make the criteria on which the Governing Council will base itself to go and get the information he or she needs. So I would like to know whether BQ1 carries. CPC 10 cannot be proposed in that case because of a line conflict. So CPC 10, there's a notice for that one, and it's later on in the list of amendments or proposed amendments. So I would like to give the floor to Mr. Caputo. Thank you, Mr. Chair, and thank you, Mr. Bellefeuille.
Anything that that limits the sweeping powers here that are granted. Let us not forget that Bill C-8 grants unprecedented substantial powers, and while we have perhaps lag behind our G7 counterparts, that doesn't mean that any legislation we pass should be passed without scrutiny and without judicious forethought as to the powers that we are granting when we are talking about potentially removing people from the internet for any sort of threat. Now, I know we've had a lot of discussions about any threat, but in this case, my understanding here is that we will be curtailing power and adding an element of proportionality. In other words, Conservatives believe, and I hope that this table will believe, that we should not be using a sledgehammer to kill a fly. Any government intervention must be proportional to the threat, and it is for that reason that I support BQ1. Thank you.
Merci, Monsieur le député. D'autres interventions?
Thank you, sir. Mr. Ramsey? It is our reading of the bill that the Governor and Council and the ministers can only take orders when it is necessary to protect the communication system, and those orders must be reasonable in proportion to the severity of the threat. So for us, this simply confirms what we had understood from reading the bill. And therefore, if it is clearer for everyone, we agree with the proposed amendment. Thank you, Mr. Ramsey. Anyone else? All right, so we can now go to the vote. Let us ask then the clerk to take votes.
If we just said on division or something like that, not that I'm against it, but instead of going through the roll call, because I know we want to.
I can do that, but I prefer to be prudent, given that it's not always possible to exactly know the point of view of everyone just by looking at faces, since do I not always see the faces, but they don't always indicate exactly how they would vote. But I can do that on this amendment, on division. Which brings us to CPC 4. Is CPC 4 moved? Mr. Caputo?
Oui, merci, Monsieur le Président.
Thank you, Chair. So I would like to move CPC 4.
Sorry, I just have to take my earpiece out. I apologize. I will speak to this amendment briefly, talking about whether a specified person refers to a telecommunication providers or a person. One of my greatest critiques of the bill as initially drafted was the nature of the vague language. I think that all the lawyers here, or anybody here, would know that vague language leads to bad results. In fact, if you want to know why a lot of laws get struck down under the Charter, it is vagueness. So precision in language is always appreciated, which is why I support and am the primary mover of C4. Thank you.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. Anyone else? Ms. Akan?
Chair. So my understanding that this requested change would create a massive security loophole. This amendment seeks and needs to narrow the scope of the security orders so they only apply to telecommunication service providers or the persons directly responsible for the security of a service. So this is described as having a dramatic and detrimental impacts on national security. Specifically, it would technically prevent the government from using Bill C-8 to enforce the 2022 policy statement, which allows for the prohibition of the equipment and services from high-risk providers, such as Huawei, in Canadian networks. So I would like to ask the expert's opinion here. Given that modern cyber threats often exploit vulnerabilities within the global supply chain, could you please explain to us the technical risk to Canada's national security if this amendment prevents the government from issuing orders against third-party high-risk vendors who are not themselves as telecommunication service providers? And would this not effectively strip the government of its power to enforce the 2022 policy statement regarding the ban of equipment and services from providers such as Huawei?
Thank you, Mr. Chair, for the question. Yes, so first I'd start by saying that the scope of the section is already on a telecommunications service provider. It gives the government the ability to tell a telecommunications service provider what it can use in its network. So the obligation is on the telecommunications service provider itself, whether it can buy certain types of equipment or procure certain types of services. If you say that a telecommunications service provider, that the restriction, but the type of corporate entity that a TSP will buy goods and services from is much broader than just other telecommunications service providers. It's equipment manufacturers, it's software producers, it's battery manufacturers, et cetera, et cetera. There's a large number of those. So basically, it's already scoped to, say, Bell Canada or whomever. There may be obligations on you in terms of what you can procure or put in your network. And the reason why it's person is because Bell Canada may procure goods and services from a wide variety of vendors. Thank you. My apologies. So if you limit the scope of that power to only being taking action against buying from other telecom service providers or other people responsible for telecom services, we can't prevent them from procuring from equipment vendors that are high risk. Thank you.
Merci, Madame la députée Akan.
Thank you, Ms. Khan. Any other comments?
So the concern generally when we talk about overbreadth relates to, like an individual citizen being targeted. In this case, is it your view or your expertise that in some cases individual people need to be targeted because they are a high-risk vendor, or are we generally talking about a corporate vendor and that's what we're talking about as person? I hope that makes sense.
Thank you, Mr. Chair, for the question. Yes, so person in the Telecommunications Act, and is a common term used, is not the same as person in a colloquial sense. And so here we're talking about corporate entities. Random individuals do not sell goods and services to telecommunications service providers. So there's no impact on individuals via this clause. And the person is referring to the legal concept of a person, which includes corporate entities.
So I suppose the legal concept of personhood does, I'm well aware of that, but the legal concept of personhood could extend to, like, say, a partnership or someone in a partnership, which is just individuals. So I guess that's where I'm caught up here, is that the legal concept of personhood extends to corporations and to people. So how are we then excluding individuals, but only including corporate entities?
So first of all, the scope of the provision, like the burden is only on telecommunications service providers. It is saying telecommunications service providers may have restrictions on who they can contract with. So if my brother-in-law had a business involving providing telecom services globally, he is not touched by this at all. The legal obligation would be on Bell or TELUS or Rogers in terms of what they can put in their network.
Thank you. Any other questions or interventions? Ms. Kirkland.
So just to clarify, I have a question based on both of the questions asked by my colleagues. So would there be any? I'm trying to understand how there's a security loophole to simply clarify that a specified person, who that refers to, because that whether I understand that person in this context doesn't mean an individual person. However, could it in any way mean that, and what's the harm in clarifying that it's not that?
Thank you, Mr. Chair, for the question. So first, again, the legal obligation is on telecommunications service providers. So the legal obligation would be on their ability to contract and procure. And TSP is already much narrower than person. So if you swap out, so the question is, who can they contract with? And if you substitute person with TSP again, you can only restrict their ability to contract with other telecom service providers. But that's not the issue. The issue is they're contracting with their supply chain. So that's why it's TSPs contracting with persons. Okay? And when we're talking about something as technical and complex as the goods and services that Bell uses to run its network, there's not an issue of individual rights. It's about we're talking about contracting between corporations.
Okay, so I understand that, and I just, so is it a security loophole? Is it dangerous to clarify it, is what I'm asking.
Thank you, Mr. Chair, for the question. So this isn't, with all due respect, this isn't a clarification. This reverses the whole legal construct of this provision. The whole raison d'etre is to be able to, if we're talking about high-risk vendor equipment, that is provided by an equipment manufacturer, not a telecom service provider, not someone responsible for the security of a telecom service. They're not involved in the day-to-day, or they may not be involved in day-to-day management of telecom service. If you swap that language, you completely remove the ability for the government to set parameters on contracting for supply chain.
Thank you very much. Madame de Bellefeuille?
Monsieur le Président, remercier.
Thank you, Chair, and I would like to thank Mr. Arbour through you for those details, because it's not easy for us to understand the wording of the bill all the time. So thank you very much for those clarifications. And I would also like to thank the interpreters behind me who are doing a wonderful job of interpreting and who enable me to follow the discussion and explanations in real time. And I really want to repeat to everyone that really having an interpreter here with us really makes a difference when we are discussing something in legal language. And I really appreciate the work that the clerk has done to ensure that interpreters are here, because it enables me to participate fully. Yes, Madame de Bellefeuille, yes, I welcome your words. Would you like to continue? I didn't want to necessarily talk about the amendment. I was hesitant, but given the explanation that Mr. Arbour has given, I will be against the amendment. Mr. Caputo, please go ahead.
Now, as I understand it here, and I want to be sure, Mr. Arbour, you have spoken about 15.1, but our clause also addresses 15.2 that says direct telecommunications service provider to suspend providing for a specified period any service to any person, including a telecommunications service provider. So there, we actually have a distinction, again, going back to the basic principles of statutory interpretation. The words speak for themselves. If we're talking about corporate entities, that would be the telecommunications provider, would it not? So why are we delineating between person and telecommunications provider in 15.2?
Thank you, Mr. Chair, for the question. First, when it comes to the considerations of individuals for the disconnection power of 15.2, there are other ways to manage that. There is one CPC amendment, for instance, to exempt the consideration of individuals from that construct. And so that would do that in a way that is actually targeted towards what I'm hearing is the concern. But if CPC 4 is adopted, it would eliminate the government's ability to put restrictions on high-risk vendors.
Okay, fair enough. I understand that. What about if CPC 4 was adopted, but only insofar as D is concerned? Would that still pose the same risk that you mentioned?
Thank you, Mr. Chair, for the question. Yes, because telecom service providers can be interconnected with servers or data centers or other corporations that can propose a dramatic risk to the telecom system, that they are not themselves telecommunications service providers. If the concern with that further section is the application to individuals, there are much more targeted ways to address that concern, in my opinion. Thank you.
Last question. Could this be used to target an individual?
Thank you, Mr. Chair, for the question. I don't believe so. Individuals are not involved in the provision of any material goods and services into a supply chain. That is the business of corporations.
See, and that's, I'm not going to ask you a question. That's where I think we disagree. I think that proprietors come in all shapes and sizes, some big, some small. to just make an assumption that people will necessarily be incorporated who are vendors. That's just not an assumption I'm prepared to make. Thank you.
Thank you for that. Anything more? In which case, I would like to ask the clerk to proceed to a roll call vote. Defeated on division? Okay, so defeated on division, which brings us to NDP 1, which is deemed to be moved. Is there someone, I see Madame Kwan wanting to speak to it? Madame Kwan?
Thank you very much, Mr. Chair. The Bill C-8 proposes unrestricted secrecy provisions with respect to the orders the government will be able to issue to telecommunications providers and other entities. So the amendment that I'm proposing would implement safeguards by limiting the grounds that justify the use of secrecy around the issuance of these orders by adopting language that is similar to that used in the Canada Evidence Act, which constrains secrecy to where it is justified on the grounds that discloses, and I quote, would be injurious to international relations or national defense or national security. So there are two components within the amendment. I won't sort of read them out because everybody's got copies of it, but it basically incorporates that language into those respective sections.
Thank you very much, Madame Kwan. Any intervention on that? Mr. Ramsey?
Oui, nous sommes contre parce que le...
Yes, we oppose it because when it comes to national security and national defense, it does not take into account the elements, the technical elements of the network. And so I think that what is in G1 and G2 will actually address this in a far more targeted and appropriate manner than this proposed amendment. Yes, and I forgot to mention that if NDP 1 is adopted, CPC 5, CPC 6, CPC 15, and PV 4 will not be able to be moved because of a line conflict. So, is NDP 1 adopted? No. It is defeated. It is not carried. So CPC 5 now, is it being moved?
I will be moving CPC 5. This is similar to the issue we discussed at length at our last meeting. And that was rather than after the fact review and determining what should happen and whether things were done right, that we figure it out at the time. Consistent with this rationale is judicial authorization for a non-disclosure order. If an order is being made by a judge, it actually makes sense that the judge should be making an order for non-disclosure. And it is for that reason that I move CPC 5 and support it. Thank you.
Merci, Monsieur le Député.
Thank you. The following decision is that Bill C-8, which amends the Telecommunications Act, will be granting new powers to the Governor and Council to include a non-disclosure clause to an order pursuant to Section 15.1. The amendment aims to amend the bill by preventing the Governor and Council to include such a provision in the order and requiring the Governor and Council to apply to the court in order to do so. In the work that you know well, the fourth edition, under Section 1674, it states that an amendment sent to a bill sent to a committee after second reading is irreceivable if it goes beyond the scope of the principle, and that is my call, and I believe that we cannot consider this amendment.
Please.
Très bien. Alors, la décision de la présidence étant remise en question, nous allons procéder immédiatement.
The chair's decision has been questioned. We must now vote. Clerk, please do a roll call vote. Thank you, Chair. So the question is will the Chair's decision be maintained? Mr. Jacques?
Yes, maintain.
Monsieur Lavoie. Madame Akan.
Oui.
Mr. Caputo.
No.
Mr. Lloyd. No. Ms. Kirkland.
No.
Mr. Au. No. Madame de Bellefeuille.
Non.
Yeas pour 4, nays contre 5.
Ce qui nous amène
That brings us to discuss CPC 5. So I am now opening the debate. Ms. Akan? Thank you, Chair.
Looking at my notes again, for CPC 5, so by making non-disclosure conditional on a federal court application, as we spoke again and again, could delay urgent action and may not capture other legitimate reasons why not disclosure may be needed, such as commercial, reputational, or technical risks to an entity or a broader system. So on that, my question will be on the response speed. So given that the cyber attacks can occur at digital speeds, which we repeatedly say we are talking about milliseconds, how would the requirement to obtain prior judicial authorization for a non-disclosure order impact the government's ability to act instantly to stop an ongoing breach without alerting the attacker that are onto them? Thank you.
Thank you, Mr. Chair, for the question. This type of concept, us as officials dealing, in talking to different parts of justice since Tuesday, we're still grappling with all of the scope of its applications, given how unprecedented it is in administrative law. And there's all different parts and pieces of it that we're finding out are new problems, and it's going to be weeks for us to unpack it all. A judicial authorization of a cabinet decision, so like how we're going to come up with a new process for how we can't bring cabinet confidence to court. This likely, we're not sure, but it likely does not match the crosswalk to the confidential evidentiary provisions of the Canada Evidence Act, so we're not sure if we could use confidential evidence with the court. From your question, though, in terms of the specific time, our best guess at this point is something that if it was truly urgent, that we couldn't, under C8 as tabled, accomplish in a matter of days is probably going to be months. And what would be months would likely be years. Thank you.
So continuing on that question, does this amendment not create a gap by ignoring the valid non-security reasons for secrecy, such as protecting a company's commercial reputation or preventing a market panic that fall outside the narrow of the national security definitions used by the courts?
Thank you, Mr. Chair, for the question. There are some secondary considerations around the criteria cited, and it is why the text of G1 is more appropriately scoped to the subject matter of Part 1. Though the judicial authorization that is the most novel part and the most challenging to implement if it can be implemented. Thank you.
Merci, Monsieur le député Lloyd, suivi.
Thank you, Mr. Lloyd, and then Mr. Caputo.
I just think it's interesting that, we're kind of being sold this fantasy that the government doesn't already have the capabilities of stopping a cyber attack that, as the member across said, could be happening in milliseconds. Like, we have a report from the Communications Security Establishment that talked about cyber attacks that they have stopped back in 2024, as recently as that. The government does have the capability of stopping these attacks. What this legislation is talking about is the removal of telecommunications equipment that could potentially cause a threat to the telecommunications system. And I want to, Mr. Arbour, bring you back to, I believe, is your testimony earlier at this committee, not today, but earlier in the study, that you said it would be extremely rare for the government to use a non-disclosure order. Do you recall making that statement, and can you clarify that you did make that statement?
Thank you, Mr. Chair, for the question. Yes, that is correct. I did say that, or a version of that.
So, Mr. Harper, like, given that you have stated that it would be very rare for the government to put in a non-disclosure order, it would have to be a situation of quite some gravity for you to want to put a non-disclosure order in. Wouldn't you agree? Like a serious
Thank you,
situation.
Mr. Chair, for the question. So the reasoning behind why an order or part of an order why it would be a good idea to have that be confidential is because there is a specific vulnerability in a provider's network, and that you may not want to advertise that vulnerability as they're fixing it until that work can be completed. The duration of how long it would take to remedy the issue in question and the seriousness of it is very case specific and would depend on these circumstances.
Thank you. But surely if it is a serious issue, which is, this is serious legislation, would not a judge consider that important information in the speed of which they make their decisions?
Thank you, Mr. Chair, for the question. There are different considerations of what is speed in a judicial context. The processes that I've been familiar with that are not done on a speedy basis are in the 12 to 18 month zone. When there is an expedited process in place, then you are more in the weeks and months.
I guess in my final kind of question, I guess, is we're being told by members from the government side that this is about stopping, live attacks on our telecommunication system. But what we're actually talking about is, potential vulnerabilities in equipment, not live attacks that are happening.
Thank you, Mr. Chair, for the question. So both circumstances are the risks that we're concerned about. So there could be, you could discover a circumstance where it's a vulnerability that's not known and that is unlikely to be discovered and might take some time for the telecom service provider to remedy. Or you might discover something that is subject to an ongoing attack and would only get worse if it's not remedied as soon as possible.
Merci, Monsieur le député Lloyd. Monsieur le député Caputo.
Thank you, Mr. Lloyd. Mr. Caputo?
We talked a lot last meeting about what we colloquially have been calling exigency, but what I will call impracticability of judicial authorization. So what Ms. Akan is talking about, she said this is going to be happening in milliseconds. Well, if something is happening in milliseconds, it is impracticable to get judicial authorization. I think we can all agree on that, which is why I had requested, and I will reiterate my request, that the drafters draft an amendment that addresses situations in which judicial authorization is impracticable. In other words, when you don't have time to get judicial authorization, but there is a threat and that threat materializes before you can get before a judge, the government is empowered to act. You get before a judge, then you get your authorization. This happens very frequently in other areas of law in which we aren't getting a warrant in the next 3 minutes. We have to take action to secure the evidence, or in this case, the system or whatever it is, the infrastructure. Then we will get this. With all due respect, Mr. Arbour, and you are much more an expert on this than I, but I, with the greatest of respect, where I part company with you is where you say that it will take months. Please walk me through this. This is the proposed amendment. A judge of the federal court may, so that also goes to Ms. Akan's point about whether you have to do something. This is permissive. It is not compulsory. So there is no requirement that a judge does institute an order. A judge can create a non-disclosure order. And when can they do it? subject to any conditions, that's pretty normal. Making an order of prohibition of disclosure. If the judge is satisfied that there are reasonable grounds are usually based on oath or affirmation, are on grounds that are made under oath or affirmation, to believe that the disclosure would be injurious to the international relations, national defense, or national security. Normally what happens in other areas is that somebody sets out why the disclosure would be injurious and how it would be injurious to international relations or national defense or national security. Like it need not be a doctoral thesis as to that. It would simply be somebody telling a judge, I believe that this is injurious to national defense because. And where I further part company with past remarks is the notion that the judge has to be an expert. The judge is listening to evidence, and that evidence is sworn to or affirmed on reasonable grounds. So if that's the case, why are we talking about 4.1 literally taking months when, as I see it, this is in affidavit form, and maybe I'm just completely missing something. So if I am, please let me know.
Thank you, Mr. Chair, for the question. The practice and conduct of criminal law and administrative law are quite different, and so we are dealing with administrative law in this context. The criteria the scope for review in an administrative law context, there's a body of case law, but the most important decision is probably the Supreme Court's 2019 Vavilov decision. So this spells out what are reasonable criteria in an administrative law context. And so the proposed provision in question is so new and so outside of the normal practice of administrative law that we're still grappling with it and still trying to unpack exactly how this could be operationalized, and it will take us some time to do so. But that's one example of the types of things that we are trying to think about how this could be implemented, along with some of the other things I mentioned, such as the provisions for the use of confidential information in this context in the Canada Evidence Act. We probably don't have a crosswalk here, but this is just one of, it's going to take us a while to try and figure this one out. Thank you.
And I'm mindful of that. This is new, but sometimes the law develops in new ways. I mean, Vavilov is obviously common law from the Supreme Court of Canada, which Canadian tribunals and then courts on judicial review are bound by. But we're creating something other than common law. We're creating statute law that tells a judge in the administrative context, which I know is a novel one, and yes, this could be very new, as you would say, perhaps dare I say groundbreaking. I don't like to say that, but you're smiling. And I'm sure it's giving some people fits, saying, what are they doing? But sometimes we actually have to challenge the process. And if challenging the process is that despite being in an administrative context, we would like a judge to see this and to make a decision on what could be a life-changing issue for parties. I get it's new, but I just don't get how, you talk about the crosswalk. Saying we don't know how it's going to work and that this is going to be different doesn't mean it's going to take months for somebody to satisfy a judge that disclosure, that there are reasonable grounds to believe that this would be injurious to international relations, national defense, or national security. I guess where I'm struggling, sir, is I don't see how that would take months simply because of the fact that this is something we're figuring out. Sometimes we do have to figure things out. Sometimes we do have to change things. Perhaps this is that time. Perhaps it isn't. That is ultimately up to the House of Commons. So that's why I'm pushing back. I hope I'm not trying to be rude or anything. I'm just really trying to put something on the table and clarify why I believe what I'm putting forward in order to get legislation that balances privacy, charter rights, and the government's necessity to protect our digital infrastructure. Thank you.
MP Pulaski.
I'm just trying to understand the issue here. So I understand the government may want a non-disclosure agreement because they don't want to advertise a vulnerability, but wouldn't that agreement be with the telecommunication provider who has the vulnerability? And why would a telecommunication provider who has a vulnerability advertise the fact that they haven't had a vulnerability? You would think.
Thank you, Mr. Chair, for the question. So yes, in the telecom service provider would have no objection to a confidentiality provision, and in fact and so there's no tension there. The issue is that there needs to be a positive power to give the government the ability to make an order confidential, otherwise it has to be public. But it's one of the reasons why for the government's proposed amendment G1, the representations by the telecommunications service provider are one of the factors for consideration that are suggested.
So the de facto is it would have to be public in order?
Oh, yes.
And where is it published, or how is it made public?
Within the Canada Gazette.
So everyone knows about the vulnerability because it's published in writing.
Très bien. Avant que j'intervienne à nouveau là, pour vous offrir la parole et vous passer un...
Before I intervene and open the vote, I should have said about CPC 5 that if CPC 5 is adopted, there is a line conflict with CPC 6, CPC 7, and NDP 2. So that means that those amendments cannot be put forth if the amendment that we are discussing right now is adopted. That being said, are there any other comments? If not, then let us proceed with the vote. Those who are for or against, a roll call vote, please. Mr. Clerk.
Le vote est sur l'amendement CPC 5.
Thank you. It's on CPC 5.
Mr. Pulaski.
Contre.
Monsieur Lavoie.
Contre.
Madame McCann.
Contre.
Mr. Caputo. Mr. Lloyd.
Yes.
Ms. Kirkland. Yes. Mr. Howe.
Yes.
Madame de Bellefeuille. Yeas pour 5, nays contre 4.
Très bien. L'amendement est donc...
Very well. The amendment is therefore carried. And that would bring us to CPC 6, but there is a line conflict with amendment CPC 5, which was just adopted. And therefore, we will now go to NDP 2.
Effectivement, il faut passer par-dessus NDP.
No, that's right. We have to skip NDP 2 because there is also a line conflict with the amendment that we just adopted, and therefore we will be moving more quickly. That will take us to Amendment G1. So we are also skipping CPC 7. So now we are at Amendment G1. Can the amendment be moved? Who would like to present it? So this amendment is aimed at introducing a number of factors that the Governor and Council must take into account before handing down a confidentiality order. So this will introduce new factors that must be taken into account by the Governor and Council, and those include what is described from A to F. So I will read them. So take into account the extent to which the disclosure could in the Governing Council's opinion, compromise the objective of the order. So that is fundamental. And it takes into account the necessity of including such a provision in light of the nature of the threat. It takes into account the possibility of limiting the scope of the prohibition, the impact of non-disclosure on the principles of transparency and accountability of the Government of Canada, and also takes into account any representations made by the affected telecommunications service providers and any other factor that the Governor and Council considers relevant. Thank you, Mr. Ramsey. Mr. Caputo.
See, I'm just
Thank you.
ask the officials something. And this is a bit of a mishmash, and the reason there is no line conflict is because this is a new provision. So given what we have decided in CPC 2 and CPC 5, this still talks about governor and council. So in order to keep the language clear, and I'm not asking for your opinion on prudence, but just from a technical standpoint, we've talked about judicial authorization. Now we're talking back about governor and council. So in order to be clear, given what has passed, should this not say where it says governor and council, should it not say judge or justice?
Thank you, Mr. Chair, for the question. Given that CPC 5 was carried, G1, so there, while not a line conflict, there is at a minimum a tension between those. G1 is probably unnecessary in this context because there's already the judicial authorization piece with different criteria that was carried as part of CPC 5. Technically speaking, like factors that the GIC would consider in recommending or suggesting that an order would be confidential don't need to be the same criteria that a judge would consider in approving it, and there is overlap in those considerations. But given that CPC 5 was carried, G1 was more an alternative to CPC 5, even if there's not a literal line conflict.
Given that there is a little uncertainty, and I believe the legislative clerk may want to have a little time to investigate this, and they might seek some guidance from outside. I'll suspend for a couple of minutes.
Let us resume the meeting. Now, let us discuss. Oh, Ms. de Bellefeuille, do you have a point of order? No. So we are dealing with Amendment G1, which is admissible because it does not enter into conflict with an amendment that was already adopted. So do you have any comments on G1? Ms. de Bellefeuille, please go ahead. Thank you very much, Chair. So I'm not sure who I should ask this question to, but when we went through the clause-by-clause examination of C12, a few times we contested your decision and the amendments were carried, and then when we got to the report stage, the chair rejected the amendments that we had adopted. And I'm worried that this might happen again. So I would vote in favor of G1 because if ever CPC 5 is rejected by the Speaker of the House, I want to make sure that we still have G1, which is very, very important. So I would encourage my colleagues to adopt G1 so that we have those very important tools that are listed in that proposed provision.
I want to build on what Madame de Bellefeuille just asked. I'm trying to think of a time where this happened, and I haven't been here as long as others. I know Ms. May is very knowledgeable about procedure, as are others. If an amendment is ruled out of scope by the Speaker, it doesn't then come back here. The bill is just as is with that excised. Is that accurate?
That is correct.
Okay. So, if I understand Madame de Bellefeuille, she's saying, well, if that happens, then G1 will not be in the bill if we do not agree with the amendment, which leaves essentially a hole. Is that? I think that's her point. Okay.
Well said. Any more interventions? Dans ce cas, nous allons procéder par...
All right, then. Is Amendment G1 carried? Yes? All right, carried. On division. Let us now proceed to Amendment BQ2. Is it being moved? Madame de Bellefeuille, please go ahead. Yes, Chair. So here we would like to change the wording by saying that the Governor and Council must take into account its impact on the provision of telecommunication services in Canada and also take into account the confidentiality and security of telecommunications. Thank you. Any debate on BQ2? No. Is BQ2 carried? Yes. Carried on division. Let us now go to Amendment NDP 3, which is deemed moved. Madam Kwan.
Mr. Chair, this amendment NDP 3, as it stands, Mr. Chair, the broad information collection powers under sections 15.1 and 15.2 could be used to undermine the privacy of Canadians, including the security of their communications. So this amendment proposes stronger privacy protection by requiring the Governor in General and the Ministry of Industry to consider the effect on privacy and the security of communications of orders issued under section 15.1 and 15.2. I note, Mr. Chair, that this amendment is similar to BQ2 and BQ3 and CPC 8 and CPC 9. Hopefully this will pass.
Merci, Madame la députée Kwan.
Thank you, Ms. Kwan. Any comments on this amendment? Mr. Ramsey? Taking into account the fact that we have other wording, we prefer the other wording, particularly because BQ2 was carried, so we will be voting against. Thank you, Mr. Ramsey. Inaudible to the interpreter. Thank you, Mr. Caputo. Is the amendment carried? It is defeated. Thank you. Now let us go to Amendment BQ3. Is Amendment BQ3 moved? It is, yes. And we would like to make a small change. We would like to add to the clause, to clause 2.18, the potential impact on the privacy of Canadians. That is the recommendation that was made to us by the Privacy Commissioner. Thank you, Ms. de Bellefeuille. Any comments on the amendment? Mr. Ramsey? Well, we think that it fits the objectives of the Act, and that is what the reading of the Act foresaw. So if it provides more comfort and assurances, then we will support it. Thank you, Mr. Ramsey. Mr. Caputo?
Can BQ3 and CPC8 essentially coexist, or are they or is CPC8? My sense is that CPC8 goes further than BQ3. Is that accurate?
Thank you, Mr. Chair, for the question. Yes, because so CPC8 refers to the privacy of persons, which once again in a legal context includes corporations. So that is not a charter right under normal circumstances. So the framing under BQ3 on the privacy of Canadians is much more legible to us and something tractable that we know how to interpret. Thank you.
Thank you for this. Any further interventions? Est-ce que l'amendement BQ3 est adopté?
Is BQ3 carried? Inaudible to the interpreter. Carried on division. So Amendment BQ3 is carried on division. Now Amendment CPC 8. Is it being moved?
Thank you. I will move CPC 8. It may be redundant given what we were just stated, but I look forward. I think the officials can feel free to chime in whether this is redundant to BQ3, which we just stated, or which we just voted on division on. But I'll leave that to the officials. Thank you.
Thank you, Mr. Chair, for the question. CPC 8 introduces quite a bit of, or is likely to introduce quite a bit of confusion. In some parts of it are duplicative of the BQ amendment that was adopted, but then we'll have two different factors. One is the privacy of Canadians, and one is the privacy of persons. Privacy of Canadians is a tractable legal concept that we can interpret. Privacy of persons includes corporations and is quite problematic and confusing. Hopefully that is clear. Thank you.
Okay, given the incongruence, given that BQ3 has passed prior to this, if it was a different set of timing, I would likely ask for a vote on this. But I'll make the decision to seek unanimous consent then to withdraw CPC 8, and we can move on to CPC 9. Thank you.
Okay. So is there unanimous consent to withdraw CPC 8? So CPC 8 is withdrawn, bringing us to CPC 9. Is CPC 9 moved?
I will not be moving CPC 9. Sorry, my apologies.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. CPC 10. There is an line conflict with Amendment BQ1, which was carried a bit earlier, and therefore it cannot be moved because we did adopt BQ1. That brings us to CPC 11. Is CPC 11 moved?
CPC 11, is there a line conflict with this? There is no line conflict as there was with CPC 10, just because we're only dealing with a very small sort of text. Is that correct, Mr. Chair? There's no line conflict? Okay. Then I will move CPC 11 to change it from a threat to a serious systemic threat, just to gain more precision in language. We are talking about infrastructure. I invite the officials to weigh in if they have any conclusions on that, but I am moving that at this time. Thank you. You're asking me to remove systemic?
That's what you said. No, you didn't say that.
My French is bad, but I didn't know my English was that bad.
This is very technical, so just make sure that everyone understood in both languages. Can you summarize again what you've just said?
Oh, I'm moving CPC 11. We'll leave it at that.
Good, that should be easily understood. MP Akan?
Thank you, Mr. Chair. So this amendment seeks to narrow the government's focus to only serious systematic threats. Here, the word systematic is technically dangerous. Again, I will repeat the same thing from the technical perspective, because it only implies a threat that must affect the entire national system to justify an order. So in reality, a major cyber attack might target one specific service provider to gain foothold or cause localized but severe damage. So this amendment would prevent the government from acting against a significant threat, and if it was not deemed systematic, leaving individual parts of the infrastructure vulnerable. So I would like to ask the experts, in your experience, do cyber actors always launch broad systematic attacks, or do they often target one specific provider to gain foothold? If this amendment passes, would the government be legally barred from issuing the ministerial order to protect a single TSP from a devastating non-systematic attack?
Thank you, Mr. Chair, for the question. So there are definite risks with this language. In part, it's a cumulative effect. So we already have a requirement that the use of this authority needs to be reasonable in relation to the gravity of the threat. So that already specifies that the use of the power needs to be commensurate with the level of the threat. So it can't be used for no good reason or for trivial reasons or anything like that, given the nature of the power itself. Adding the word systemic is not defined or not a technical term that is familiar, and given that the phrase telecommunications system is already existing language that this is a new novel variant of, it appears that it could imply that that is only the attack on the entire system is what the power could be used for. However, an attack on an individual service provider could still affect millions of Canadians.
Thank you. So technically speaking, if a threat is detected that has the potential to become a systematic threat, but currently impacting only one network, does the inclusion of the word systematic force the government to wait for the damage to spread before it has a legal authority to intervene?
Thank you, Mr. Chair, for the question. It's possible. We don't know how this term would be interpreted, and given the other guardrails on the use of the power, there is a very real risk that it would be interpreted in such a way that only something on the scale of the entire system would be a threat that we could target with it.
My last question will be from a policy perspective. how would the ambiguity of the term systematic impact the speed of response during a cyber attack or cyber emergency if the government lawyers have to first determine whether a threat meets this high threshold before an order can be issued?
Thank you, Mr. Chair, for the question. Certainly, these types of things add non-trivial delay in terms of how we work through these things. This level of ambiguity, it's difficult for me to predict how much time the lawyers would need to work through this in an individual context. And it would depend on the nature of the threat, but it could impose non-trivial delay before the government was comfortable to act.
Merci, Madame la députée Akan. Monsieur le député.
Thank you, Ms. Akan. Mr. Caputo?
Thank you. What about if there was an or to be added, serious or systemic? In which case either one could be satisfied, and how would that compare with G1.2, for instance?
Thank you, Mr. Chair, for the question. If the or were to be added, then that would remove the issue with systemic, because the government could act with respect to a serious threat. It would likely make the language potentially a little redundant given the reasonable grounds clause, but that would likely be manageable.
I'm not sure if my colleagues would consider it a friendly amendment to change the comma to or.
Oh, sure. Monsieur Ramsey?
Mr. Ramsey?
And when you say serious threat, something that is potentially can become very important and have huge consequences, but at a time that doesn't have that is not that serious. Could it be interpreted so this is not serious, so we can't do anything about this at this point in time? So relating to the potential of becoming huge and important.
Thank you, Mr. Chair, for the question. It's unlikely that would be an issue. Given the nature of the power that we're talking about in terms of suspension or kind of disconnection of service, in plain language, it would only be used for a serious issue. Otherwise, there are less intrusive means that could be used, most likely. So the main issue when we looked at this was it can be a bit odd in terms of its drafting, given the other parts of the bill. As I mentioned, it's a bit odd to put this when there's already the reasonable grounds proportionality consideration, because that's already all we need to tell you. You could only use it for a serious threat. So when we engage with the lawyers, sometimes they frown and are concerned about that. But other than some potentially awkward drafting, we didn't identify major concerns with the word serious.
Merci à tout le monde.
Thank you, everyone. Any other comments? In that case, Mr. Caputo, is there a sub-amendment that you would like to make? Somebody else would have to propose it in your place.
Speak directly with Madame de Belfay. I'm not sure whether she would be open to the sub-amendment, or if it's not going to be voted yes on, then there's no point in dealing with it. So my sense is that this is going to be rejected on division. So I won't put forward a sub-amendment, and the amendment can be rejected with a note of division on division, please.
So you want to submit
I don't want to put a sub-amendment on the
good.
floor because it will just be rejected.
Good.
Thank you.
Well understood. Thank you for the clarification. So is CPC 11 adopted? Rejected on division. CPC 12, is CPC 12 moved?
Thank you, Mr. Chair. I will move CPC 12 to clarify, and I believe this may have been raised by the officials to clarify that an order under Section 15 of the Act cannot be used against an individual to, again, add precision to the language.
Thank you. Any interventions? So is CPC 12 adopted? Oui. Alors, adopté.
Yes, carried on division. And that brings us to Amendment NDP 4, which is deemed moved. Ms. Kwan?
Thank you, Mr. Chair. NDP 4, the rationale behind it, Mr. Chair, is that despite the stated objective of strengthening cybersecurity in Canada, many experts in civil society groups have noted that the bill creates broad powers that can be used to undermine Canada's cybersecurity. So under Section 15(2) of Bill C-8, it can be used to issue orders that weaken the encryption standards in telecommunication networks. And currently, the government could use Bill C-8 to compel telecommunications providers in Canada to install backdoors inside of Canada's networks, including lawful access-related capabilities. So this amendment adds an interpretive clause to Section 15(2) that is intended to limit the government from demanding that telecommunications providers enable invasive activities by balancing the confidentiality, integrity, and availability of Canada's networks. So this amendment was, in fact, recommended in the joint Civil Society Senate submission on Bill C-26. And I note that this is exactly the same amendment as CPC 13 and CPC 14. Hopefully, this will pass.
Okay, thank you, Madam Kwan. Indeed, NDP 4 and CPC 4 are identical. Sorry, CPC 14, so NDP 4 and CPC 14 are identical. But to my knowledge and in my understanding, CPC 13 and NDP 4 are not the same. So we will now debate and eventually vote on NDP 4, but we will not then thereafter turn to CPC 4 because these two being identical amendments. So having heard MP Kwan, any interventions on that amendment? Madame Akan?
Thank you, Mr. Chair. While the terms confidentiality, integrity, or availability sounds protective, however, in my opinion, again, they are dangerously overboard in the technical sense. Specifically, the term availability is a major issue. So if the government orders a company to replace a faulty or a vulnerable equipment, that process might temporarily take a system offline, which technically impacts the availability. So these amendments could be used to legally block the government from requiring the removal of the high-risk equipment, such as Huawei, or fixing legitimate security flaws because the act of fixing them causes a temporary disruption. So my questions will be to the experts and the technical speaking. If the government identifies a piece of hardware in our network that has compromised by a foreign actor or others, its immediate replacement, would the inclusion of the legal ban on impacting availability prevent us from acting if the replacement process requires a temporary service outage?
Thank you, Mr. Chair, for the question. That is a very substantial risk with the way this amendment is worded. I would start first with order making can only be used to protect the telecommunications system. That's how C8 is scoped. It cannot be used to order processes to further law enforcement or other matters. So there's already not an ability to order the breaking of encryption under this provision. I totally appreciate that there are some civil society concerns about that possibility, and they're seeking a for greater certainty clause. In this case, though, it doesn't mention encryption. It's just very vague, and that given that encryption is already not permitted, like breaking is already not permitted under the Act, there's a very high risk that this would have substantial collateral damage. And it's when replacing equipment or fixing equipment, sometimes that can be done without any interruption, but sometimes you need to take a piece of hardware offline in order to patch it or replace it. And so this would have that collateral damage. And I believe that's why the government's G2 amendment that speaks specifically to the issue of encryption focuses more on the issue at hand.
Oui, Monsieur le député Ramsey.
Mr. Ramsey? I just wanted to draw your attention, Mr. Chair, to the amendment that we have moved linked to this concern. It is particularly clear that the minister cannot order the decrypting of a private communication that is encoded pursuant to Section 83, to a section of the criminal code. So really, that is clear, and I really do prefer the amendment that we have moved to the one that has just been moved.
Merci, Monsieur le député. D'autres interventions? Madame de Bellefeuille?
Ms. de Bellefeuille, any other comments? Yes, go ahead. Yes, I am one of the members of the committee that expressed a number of concerns on decrypting. And like Mr. Ramsey, I feel that Amendment G2 really does express what I wanted the minister to clarify, and I think that the minister made a commitment when she came here to provide testimony. So I will be voting against NDP 4, and I will be supporting G2, which meets the concerns raised by Ms. Kwan, but more clearly when it comes to the issue of decryption. Thank you very much. Any other comments? All right. Is Amendment NDP 4 carried? It is defeated on division. And that takes us to G2. And is Amendment G2 moved? Yes. So for the same reasons that I just laid out, it meets the concerns that were expressed during the work of the committee. And it can reassure anyone who believes that it is possible to decode an encrypted private communication. So this is an assurance that the government wished to provide within the bill. Thank you.
I appreciate what the government's trying to do here, but I do note that there are other amendments later on that seek to expand the definition of what a private communication means beyond what the criminal code states currently. I'm wondering if the officials could tell us, there's some concern that under the criminal code definition of a private communication, it's not expansive. It doesn't include things like metadata. So what would be, if we were to pass this amendment, what would be the impact on future amendments that seek to expand the definition of a private communication beyond what the criminal code states?
Thank you, Mr. Chair, for the question. The text here is just specific to this provision. So it just refers to this provision specifically. I'm sorry. I'm not entirely sure I understand the question.
Okay. Maybe I'll ask the analysts. You do note later on there are some amendments that deal with the idea of the definition of a private communication. Now, private communication is outlined in the criminal code under section 183, as it says in this. But there was some concern from witnesses that that definition is not as encompassing as it needs to be to protect the privacy of Canadians' communications. And I believe I think there's a Green Party amendment on this as well. And so I'm wondering, what would the impact of passing this amendment have on future amendments that touch on the definition of a private communication as outlined in the criminal code?
I will suspend for a minute just because I am uncertain as to whether they are able to answer that on their own, and I'll be back in a second. Maintenant, recommencer.
Let us resume the meeting.
For your patience, there are two pieces to MP Lloyd's question, the procedural piece and the legal piece. The legal clerks are advising me, as I understood earlier, that all of these amendments, including this one, are in order, so we can and should be discussing them. If there are legal conflicts, then it's up to the experts to establish whether they exist and why they exist. So, Mr. Arbour, if you have something to add, the floor is yours.
Yes, thank you, Mr. Chair. So, yes, I was able to do a cross-reference with PV3. So those have two different definitions, but there's nothing to say that this, for this part, we're, at least from a policy standpoint, they both refer to the criminal code, and a different one gets into some other issue. But the government amendment has to deal with issues around encryption and, pardon? I do not think they conflict.
Thank you. Any more on G2? Is G2 adopted? On division, thank you. Moving to CPC 13, is CPC 13 moved?
Thank you, Mr. Chair. I will move CPC 13. Thank you.
Any input into CPC 13? Madame la députée Akan?
Thank you, Mr. Chair. It's just the same concerns that I have as NDP4. Again, I feel like it's exactly applying the same thing that I mentioned in NDP4, that it is affecting the government's ability to act. So I will be opposed to that. I have the same concerns.
Merci, Madame la députée Akan.
Thank you, Ms. Akan. Any other comments? Is Amendment CPC 13 carried? I believe that the answer is no, so it is defeated on division. Let us now move to PV1. It is deemed moved. Madam May? Thank you, Chair.
I want to put on the record again that the procedure to which, I don't know if Madam Kwan objects to the procedure, but each committee passing the identical motion makes a mockery of the idea that committees are masters of their own work. And this has been how parties of MPs belonging to parties that have fewer than 12 MPs have had to work for some time since the motion was first invented by Mr. Harper's PMO, adopted by Mr. Trudeau's PMO, and now by Mr. Carney's PMO. So I do need to put on the record that we would have the right as smaller parties, as MPs, to put individual amendments, such as we are doing here, on the floor at report stage. Those are our rights under the rules. They are denied when we have this particularly strange procedure. So I know that it may stretch credulity that I'm not thrilled that this is my opportunity to participate, and I appreciate the fact that amendments are being carried on C8 that are very close to what we do want to see in terms of having heard the witnesses and looked at the evidence from so many groups. So I'll keep my remarks brief because your motion does allow each member of Parliament whose motion, because I'm not a member of any committee, is deemed to be before you. I find the strictures unpleasant compared to the rights we have at report stage. Merci, Monsieur le Président, et encore désolé.
Thank you, Chair. I apologize again.
His first amendment here is to deal with the question of encryption, to bring it back to mind. We've had many witnesses before this committee who've spoken to the question that that we need, particularly, we've seen the weakening in C8 of some technical safeguards, notably encryption. So witnesses before, particularly the Canadian Civil Liberties Association, pointing out that robust encryption is critical to any efforts to secure telecommunications systems. And despite this technical reality, government agencies have repeatedly failed to prioritize cybersecurity over surveillance and sought to bypass encryption. So this amendment's very clear. It would just add the language to at page 4, line 41, clause 3.1. The language remains the same except for adding including encryption. Merci, Monsieur le Président.
Thank you, Chair. Thank you. Ms. May? Is there a debate? Mr. Ramsey? I would simply say that I think it's redundant given that we adopted G2, so we would be voting against. Any other comments? Is Amendment PV1 carried? It is defeated on division. Ms. May, your Amendment PV2 is deemed moved. Would you like to introduce it? Mr. Chair, yes, I would.
But again, relying on evidence before the committee from the Canadian Civil Liberties Association and others. And I know there are some policy overlaps with other motions, but no line conflicts of which I'm aware. So in this amendment, in C8, service providers can be compelled to install highly intrusive surveillance and capabilities for cybersecurity purposes. But once these capabilities are in place, it's belief of a number of experts, and certainly the Green Party view is C8 fails to ensure that their use is limited to cyber defense. Again, the Civil Liberties Associations are particularly concerned that the capabilities that are enabled and imposed through C8 could be used or will be used by security agencies to achieve objectives that are unrelated to cybersecurity, again, intruding on the rights of Canadians. Thank you, Mr. Chair.
Thank you, Madame May. And the intervention is PV2 adopted?
In favor.
In favor? So we'll, I think it's, again, adopted, rejected on division? Let's have we haven't exercised for a little while, so let's do a roll call vote.
Thank you, Mr. Chair. The vote is on Green Party Amendment number 2. Monsieur Ramsey?
Contre.
Mr. Pawlowski? Monsieur Lavoie?
Contre.
Ms. Akan?
Contre.
Mr. Caputo?
For.
Mr. Lloyd?
In favor.
Mr. Gill?
For.
Mr. Au? Madame de Bellefeuille? Yeas pour 4, nays contre 5.
Merci, Monsieur le greffier. L'amendement est
Thank you, Mr. Clerk. The amendment is therefore defeated. And that brings us to Amendment BQ4. De Bellefeuille, I withdraw my amendment because I think that G2 covers my concern. Very well, then the amendment is not moved. Then let us go to Amendment PV3. Ms. May, would you like to speak to it?
I'll address it briefly as well. Of course, this amendment, as you have before you, affects line 3 on page 5. This, again, was a recommendation that the risk of, as the government is able to compel telecom service providers to intercept categories of Internet traffic that are of a highly sensitive nature. So the amendment as proposed limits this to, say, tracking data or transmission data, as those terms are defined under the criminal code, an amendment to ensure that the intrusions are balanced and limited as much as possible. Thank you, Mr. Speaker.
Thank you, Madame May. Any interventions on PV3? Is PV3 adopted? So I see some in favor, some against. My reading of the room is that this is rejected on division. So rejected on division. PV4. Would you like to speak to PV4, Madame May?
Thank you very much. Yes. Again, this is dealing with the telecom service provider being ordered to disconnect and targets in order to access the internet and mobile networks where there are reasonable grounds to believe that in doing so. Our amendment here is to require individual notification for people whose internet access is blocked, as well as public notification for those blocked websites. I know there are similar provisions in the bill for notification and public awareness, but this is specific in ensuring that the minister must, without delay, notify the person affected of that order, and then again take that information public. Thank you, Mr. Chair.
Thank you, Madame May. Si PV4 est adopté.
If PV4 is carried, CPC 15, Amendment CPC 15 cannot be moved because there is a line order, a line conflict. Point of order, yes. Could we get a a decision from the chair with regard to the scope of the amendment because it goes beyond the scope of the bill. So what the legislative clerks are telling me is that that the amendment is in order, but there is a line conflict. So if the committee adopts this, then we will not be able to vote on CPC 15. So is Amendment PB4 carried? It is defeated. And that brings us to Amendment CPC 15. Is Amendment CPC 15 moved?
We'll move CPC 15.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. So regarding CPC 15, my decision is as follows. As we know, this bill amends the Telecommunications Act and provides new powers to the minister to include a non-disclosure order or provision to an order under Section 15.2. The amendment seeks to amend the bill by preventing the minister from including such a provision in the order and requires the minister to turn to the court. And in the House of Commons Book of Procedure, 4th edition, under Article 16.74, it states that Amendment 2, a bill sent to committee after second reading, is inadmissible if it exceeds the scope and the principle, and the chair has or deems that it does go beyond the scope and the principle because it makes it possible for a judge to extend the time required, and that goes beyond the scope and principle, and therefore the amendment is inadmissible. Mr. Caputo?
To challenge the chair's decision, please.
Merci, Monsieur le député. Nous allons donc procéder à un vote sur la décision.
Thank you, Mr. Caputo. We will therefore vote on the chair's decision. Clerk, please, a roll call vote.
Vote is on the decision of the chair that CPC 15 is out of order. Shall the decision be sustained? Monsieur Ramsey? Mr. Pawlowski? Monsieur Lavoie? Ms. Akan?
Oui.
Mr. Caputo?
No.
Mr. Lloyd? No. Mr. Gill? No. Mr. Au? No. Madame de Bellefeuille? No. Yes pour 4, nays contre 5.
Merci, Monsieur le greffier. Nous allons donc...
Thank you, Clerk. Now let us proceed to the debate on CPC 15. Any comments? Mr. Chair, I think we can go right to the vote. I think that we have already made a number of comments. If that is the committee's will, any other comments? Therefore, let us, well, is Amendment CPC 15 carried? I can see that we will have a roll call vote. Mr. Clerk, go ahead. Thank you very much. Mr. Chair, the vote is on Amendment CPC 15.
Contre. Mr. Pawlowski?
Against.
Monsieur Lavoie?
Contre.
Madame Akan?
Contre.
Mr. Caputo? Mr. Lloyd?
Yes.
Mr. Gill?
Yes.
Mr. Au? Madame de Bellefeuille? Yeas pour 5, nays contre 4.
Merci. L'amendement...
Thank you. Amendment CPC 15 is therefore carried. And let us now go to Amendment G3. Is it moved? Please go ahead, Mr. Ramsey. So the amendment seeks to add a number of factors that the Governor and Council must take into account before issuing an order on confidentiality, and that these are the factors that the minister must take into account in order to better frame those orders. I have already mentioned that C8 has a number of checks, but at the request of the witnesses who have come to committee, we have added this to make it clearer. So there are the 6 subsections that clearly lay out the circumstances in which an order can be made, and they are the same as those that are in G1 with regard to the Governor and Council. Thank you. Comments? Mr. Caputo?
Officials, please. I assume that this is the same situation as we were dealing with before, wherein there is a fundamental disparity between C5 and, when I say C5, Amendment C5 and Amendment G3, in that the only reason to pass G3, given the language in C5, is in the event that CPC5 is ruled out of scope by the Speaker. Is that correct?
Thank you, Mr. Chair, for the question. I mean, ultimately, it's to elected officials in terms of how you wish to proceed with this type of circumstances. But yes, if you are concerned about the Conservative amendment being struck down the road, then supporting this amendment would make sure that this one was in place should that eventuality occur. Similar to what we had with G1.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. Any other comments? Is Amendment G3 carried? Carried on division? Carried on division. Now, Amendment CPC 16. Is it moved?
Before we begin, could I ask the officials a question before I move this, please?
Yes.
Okay. Given that there is judicial authorization, does this still need to be moved because it would allow TSPs to request judicial review? I guess in one case you're seeking judicial authorization in advance. In the other instance, this is seeking requesting judicial review. Do the officials have any comment on that, please? Whether the two the two go hand in hand?
Thank you, Mr. Chair, for the question. Yes, so this provision actually is doubly duplicative, most likely. At a minimum, it's duplicative of the rights that TSPs would already have to challenge an order under to the federal court. Even if the authorization circumstance didn't exist, there are problems with this in terms of when you have a provision in law, the assumption from a statutory interpretation standpoint is that it's there for a reason, that it's doing actual work. Adding something duplicative creates confusion, and you run the risk that in another provision that doesn't mention the right to appeal to the federal court, it could be interpreted as the drafters are saying that you don't have that right in a subsequent process. Okay.
So just to be clear, it is the official's position, or is your position, Mr. Arbour, that there is 100% a right to judicial review as the bill is drafted? 100%?
100%, yes. How appeals work more broadly in terms of the Federal Courts Act and subsequent.
That was the issue, was the necessity to spell it out. So if you're 100% confident and we have the other issues, then I will not move this amendment.
Thank you for that clarification, MP Caputo, which then brings us to CPC 17. Is CPC 17 moved?
One moment, please. Just one moment here, please. This, no, I will not move this amendment.
Thank you, MP Caputo. You are doing, I shouldn't say that to someone from another party, but you're doing a very good job. It's not easy to follow the flow and the coherence of all of these amendments, so well done. Which brings us to CPC 18. CPC 18, is CPC 18 moved?
Yes, I would like to move this amendment, please.
Thank you. Any interventions on CPC 18? L'amendement CPC.
Is amendment CPC 18 carried? It's too late. Unfortunately, I called for the vote, so let us now proceed by roll call vote. Mr. Clerk?
Merci, Monsieur le Président. Le vote est sur amendement.
Thank you, Mr. Chair. This is a vote on amendment CPC 18 by the Conservatives. Mr. Ramsey?
Mr. Pawlowski? Monsieur Lavoie? Contre. Ms. Akan?
Contre.
Mr. Caputo?
In favor.
Mr. Lloyd? Mr. Gill?
Yes.
Mr. Au? Yes. Madame de Bellefeuille? Yeas pour 5, nays contre 4.
L'amendement CPC 18.
Amendment CPC 18 is therefore carried. And this brings us to Amendment PV 5. The amendment is deemed moved.
Madame May.
Yes, please. Thank you, Mr. Chair. And of course, again, under the terms of the motion the committee adopted, all of my amendments are deemed moved. So thank you for having somebody magical put it before you. Nobody else is allowed to speak to it, I suppose. So I will at this point. I feel very strongly about this one. And I also note that it's a line conflict with the Conservative Party Amendment 19. And it's nice to be in such strong agreement with Mr. Caputo on so many amendments. I'm really quite shocked that we have legislation brought before us which so clearly will not meet the standard of Section 8 of the Charter. The witnesses on this were many, but I was particularly struck that our Intelligence Commissioner, Honorable Simon Noel, spoke so clearly to this point. This amendment attempts to redress that problem by ensuring that before interception of and production of information is compelled, that there be a process of judicial review, that it be obtained, that such personal information can only be obtained if proportionate and necessary and judicially authorized. And the evidence before this committee from the Intelligence Commissioner was very strong. And having actually read and weighed the charter statement put forward by the minister, again, to remind you, the Intelligence Commissioner said, I haven't seen anything in that statement that would give a justification under the charter. It's in fact, it's totally absent. So the amendment put forward, as you can see, the Green Party amendment, Parti Vert, Amendement 5, c'est un peu plus...
So it's Amendment 5. It's a bit longer than the others.
And they need to be set out as to how the minister is constrained. The minister must not require under subsection 1 the provision of information relating to a person or a group of persons unless the minister first obtains the authorization of a judge. I could go on because it's very clearly important.
Unfortunately, Madame May,
Wait.
with all the respect and the esteem I have for you, I have to,
Oui, je
for
comprends
reasons
bien.
of equity.
Oui, oui, non, d'accord, mais c'est important.
Yes, I understand, but it is important, and I hope that this amendment will be carried. Thank you. Thank you very much, Ms. May. I have two comments on the amendment. As Ms. May alluded to, if the amendment is carried, amendments CBC 19 and CBC 20 cannot be moved because of what is called a line conflict. The other thing is that, according to the chair, the amendment is not in order for the following reason. The bill that we are studying gives the minister the power under section 15.4, the power to order that information be provided to the minister if the minister feels that it is necessary to ensure that an order is being respected under 15.1 and 15.2. The amendment would require the minister to obtain the authorization of a judge to be able to proceed with such an order in certain circumstances. In our well-known tome, it states that an amendment to a bill that is sent to committee after the second reading is out of order if it exceeds the scope and principle of the bill. So the chair is of the opinion that introducing a judicial review before the orders is a new concept that goes beyond the scope. Mr. Caputo?
Tomorrow, or if this is Ms. May's last time when I say tomorrow, next meeting, but I would be challenging the chair.
Donc, la décision de la présidence est remise en cause. Monsieur le greffier.
The chair's decision has been questioned. Clerk, please let us begin a roll call vote.
Shall the decision of the chair on Green Party Amendment 5 be sustained? Monsieur Ramsey.
Pour.
Mr. Pawlowski. Monsieur Lavoie.
Pour.
Ms. Akan. Mr. Caputo.
No.
Mr. Lloyd. Mr. Gill. Mr. Au. Madame de Bellefeuille.
Pour.
Merci.
Yeas pour 5, nays contre 4.
La décision est donc maintenue.
The chair's decision is therefore sustained. And given the time, I believe that we will now adjourn and we will resume next Tuesday. As you know, the following Thursday, we have a different agenda. So thank you, everyone, and good evening.
Thank you.